Good morning and welcome to the committee's 7th meeting in 2021. I ask you please to all ensure that your mobile phones are on silent. Now the meeting will be conducted in virtual format. First item on the agenda is the Dogs Protection of Livestock Amendment Scotland Bill, Stage 2 consideration. I'd like to welcome the member in charge of the bill, Emma Harper. I'd also like to welcome Christine Graham, who is the committee substitute for Emma Harper for this item. And I would also like to welcome Ben McPherson, the Minister for Rural Affairs and the Natural Environment. Before we go any further, I would like to ask members if they would like to do a declaration. I'm going to start this off by saying that I have recorded in my register of interest that I'm a member of a family farming partnership in Murray. Peter Chapman, followed by Stuart Stevenson. I think you'd like to give declaration.
Convener, I declare that I am a member of a farming partnership also.
Thank you. Stuart Stevenson, followed by Jamie Halcrow-Johnson.
I jointly own a very small registered agricultural holding from which I derive no income.
Thank you. And Jamie Halcrow-Johnson.
Thank you, Convener. I'm also a partner in a farming business.
Thank you very much. I would like to now, just before we begin, recap on how the Stage 2 process will work in the virtual setting. Members, the member in charge and the Minister will be called to speak to their amendments in the usual way. Members who have not lodged amendments in a group but who wish to speak should indicate that by inserting an R in the chat function, and I'll make sure that you're called. Voting on any divisions will be carried out electronically using the chat function. I will separately call on members to vote either yes, no, or abstain. Committee members should type in their vote into the chat box: Y for yes, N for no, A for abstain, and the result will be read out in full with the names of who voted for each option and the vote result. It is absolutely vital that this is done to ensure that the correct vote is recorded. Now, as has happened before, if there is loss of connection during the Stage 2 proceedings, if we lose connection to any member or to the Cabinet, to the Minister during Stage 2 proceedings, I will suspend the meeting until the connection is re-established. In the unlikely event that reconnection is not possible, we will need to reschedule our Stage 2 consideration. If a member loses connection at the point where he or she is required to move an amendment and the connection cannot be restored after a brief pause, then another member from the same party group will move the amendment. The member will also have an opportunity to speak to the amendment if it has not already been debated. If the member who is required to move the amendment loses connection and does not have a party group member to move their amendment, I will suspend the meeting to allow the connection to be restored. If a committee member loses connection at the point at which a division is called or a division is taking place, then I will suspend the meeting for up to 10 minutes to allow the connection to be restored. During that period, the clerks will contact the member who has lost connection and clarify whether she or he is content for the vote to proceed without her or him if the connection is still lost. In addition, the vote will only be delayed beyond the 10 minutes in the likelihood of a close division. So I hope that adequately explains it. So we'll now move on to consideration of the amendments. And first of all, I'd like to call Amendment 1 in the name of John Finney in a group on its own. John Finney, please to move and speak to Amendment 1. John.
Thank you very much indeed, Convener, and I do move Amendment 1 in my name. I think this is about exemptions to this fine piece of legislation we have in front of us, and I think first of all that many people would be surprised to understand that there would be any exemptions at all, not least given that this is a significant animal welfare issue, the protection of livestock. The clue is in the name. And my proposal is a very simple one, and that is that I think we would all readily accept that it's a bad idea to have a dog loose among livestock, with the notable exception of the dogs of the stock person's dog, be they sheep, cattle, whatever. And it's an even worse idea to have a number of dogs loose. Now, I would be saying this regardless of whether we're talking about sled dogs, greyhounds, terriers, whatever. The existing exemption for police dogs is appropriate, and I perhaps should declare I'm a former police dog handler in the circumstances in which police dog handler would find themselves in livestock. I think ideally, in many instances, you would want to encourage the possibility of the livestock being relocated if you were conducting a search for property, for instance, and that could be stolen property, that could be specialist dogs looking for explosive drugs, firearms, indeed human remains. But the reality of the situation is that it's a key role, that, and it is about the protection of life or property. So properly controlled, and the police dog would be properly controlled, I think that's an appropriate exemption. But we have a situation where there's no logic in retaining a situation where livestock could be subject to the intrusion of a group of dogs for whatever reasons, not least because of the impact that can have. And you know this as a convener, as a farmer, the distress that can be caused to livestock, full stop, compounded if the livestock is pregnant livestock, or indeed nursing livestock, if that's indeed the correct term. So there is trauma associated with that, and for all of those reasons, I move this very reasonable amendment. Thank you very much indeed.
Thank you very much, John. I have got some members who wish to speak in this. I'm going to go to Mike Rumbles, followed by Jamie Halcrow-Johnson. Mike.
Good morning. Yes, I don't agree with John's amendment. There are exemptions already in this legislation, as John's referred to them. John himself said there was an exemption for police dogs, and also that it's about a dog being lawfully used in pest control, and that's the law at the moment. And what John would do is to remove this lawful activity from this bill. I don't think there's any need for it. I don't want to go back to rehearse arguments that we've had over the last 22 years on hunting with dogs. This is about dogs being used for pest control. And if the committee accepted John Finney's amendment, then I think that would lead to a lot of problems. So I don't support John. I know he's well intentioned for bringing it, but I ask him not to move it, because I don't think it would have the support of the committee members, but I'm willing to listen. Thank you.
Thank you, Mike. I'll go to Jamie Halcrow-Johnson, followed by Christine Graham.
Thank you, convener. I won't rehearse the kind of position that Mike Rumbles made, because I think it sums up really my concerns with this. This is around issues of pest control. The dogs that would be being used would have permission of the landowners, farmers, to be there, and so I think it is a more ideologically based amendment, and not regards to the welfare of livestock, so I won't be supporting it.
Thank you, Jamie. Christine Graham, followed by Colin Smith.
Thank you very much, convener. No, I will be supporting it. I mean, by group of dogs, I mean, let's be honest, we're talking about fox hunting by another name. That's all I can think about here. I have totally opposed fox hunting. I have no problem, frankly, with banning it, but that's not what we're talking about today. And this is not the place for that particular amendment. Secondly, I don't recall this being teased out at stage one in an evidence session, and I'm old-fashioned. I think at stage one, if you're going to bring things forward at stage, you should tease out the evidence, allow parties on either side or the group of people that may be interested in this to give their evidence and tease this out. So while I wholly support what he's trying to do, this is the wrong place. We haven't taken evidence, and on that basis, I will not support it.
Thank you, Christine. Colin Smith.
Thank you very much, convener. I mean, Amendment 1 from John Finney is entirely reasonable amendment. It removes the exemption allowing dogs to be at large in a field with sheep, provided they're part of a hunt. And that, frankly, removes what is a totally unnecessary loophole, which we know causes a great deal of distress for sheep. The exemption legitimises what is a cruel so-called sport that should rightfully have been banned almost a decade ago. Well, I appreciate that the exemption does not allow those dogs to attack or chase sheep. The distinction between these is not at all clear. Christine Graham has just said this wasn't teased out in evidence. We didn't take evidence on this. We did so. In their evidence to the committee, the Scottish Steering Group of the UK Centre for Animal Law raised the issue. They pointed out that, and I quote, numerous incidents have been observed in Scotland where packs of foxhounds have been hunting in proximity to flocks of sheep, causing sheep to panic and run, even if they're not strictly chasing them. Similarly, One Kind called for this particular exemption for hunting to be removed altogether, highlighting that even if you're not attacking or chasing, quote, packs of hounds in the vicinity of sheep can cause them considerable stress. They also highlighted the crucial point that unlike other exemptions in this section, they are not providing an essential service. This is a point I also highlighted in the stage 1 debate. So we have discussed and we have debated this particular issue. There is good reason the law requires dogs to be kept under control in the countryside. Now, I can see, frankly, no practical reason why this exemption should continue. There's a practical exemption, for example, for sheepdogs because of the specific nature of their role, and also for guide dogs. But this exemption, frankly, turns a blind eye to the problem to livestock caused by hounds hunting foxes. It means one law, frankly, for blood sports and one law for families walking their pets. And I can see no justification for this to continue. There is no justification, frankly, for hunting to continue, but the very least we can do is to hold hunts to the same basic rules that we're asking the general public to follow. I think it's an issue, as I said, I highlighted in my evidence and my debate during stage 1. So I thank John Finney for raising this important issue. And I would urge members to support the amendment, particularly those who claim to be opposed to fox hunting. But, you know, actions do speak a lot louder than words.
Thank you, Colin. Just before I go to the Minister, I would like to pass comment on this bit, if I may. Considering the wide area of ground that can be farmed and used for grazing in Scotland, which includes on the margins of hill ground, areas of juniper bushes and gorse bushes, it is entirely proper under the legislation that dogs can be used to flush foxes from cover. And that is what the law allows. It doesn't allow hunting, and I regret that I think Colin has misunderstood the legislation in Scotland regarding hunting. So I think it's entirely proper. I think it would be improper to try and contain and move sheep out to allow that activity to go on. Therefore, I think the amendment is faulty, and therefore I will not be supporting it. Now, no other member has asked to speak, so I'm going to move to the Christine Graham, do you want to come in again? I truthfully like people to come in once and then move on. Christine.
Attacked by Colin Smith. I mean, I defer to no one in my position regarding fox hunting. But I don't think you slide that into a bill which is to do with a broad Dogs Protection of Livestock Amendment bill. If you're going to ban fox hunting, which I want to do, you do it in a standalone piece of legislation, then that is my position. So in defence of myself, it's not that I approve of it, it's that I don't approve of this particular amendment in this particular bill.
Thank you, Christine. And I'm now going to move on to the Minister before I call the member. Minister.
Thank you, Convener, and good morning all, and thanks for the opportunity to respond on this amendment. First of all, let me be clear that this Scottish Government is clear that the legislation introduced in 2002 to protect foxes from unnecessary hunting has not had the desired effect, and we have committed to take forward many of the recommendations from Lord Bonamy's review to clarify and strengthen the Protection of Wild Animals Act 2002. And while I understand why John Finney might wish to try to advance the agenda of protecting foxes through this bill, there are a number of issues with his amendment. Currently, it is an offence for a dog to be at large, that is to say, not on a lead or otherwise under close control, in a field or enclosure in which there are sheep. One exemption to this is when the owner of the dog is there with the permission of the owner of the sheep. Another exemption is for police dogs, guide dogs, trained sheepdogs, working gun dogs, or a dog lawfully used to hunt. This last part of the definition could include situations where a dog is being used to control rats or rabbits at the request of a neighbouring farmer or landowner, as well as dogs being used to support people on foot carrying out legitimate fox control. In these situations, it seems completely disproportionate to make it an offence to do something that does not actually cause harm to livestock and may be incidental to a perfectly legitimate use of a dog. The bill as introduced would extend this exemption to include other assistance dogs, while adding the condition for all types of dogs that the exemption will apply only if and to the extent that the dog is performing the role in question. This amendment from John Finney would unhelpfully remove that added condition for all the types of dogs, including police dogs and trained sheepdogs. Regarding the issue of fox control, we are strongly committed to safeguarding animal welfare, including that of wild animals and notably foxes. But it's disappointing that, owing to the need to prioritise our response to the unprecedented challenge of COVID-19, we have not been able to bring our fox control bill forward in the timetable originally planned. And it is because of the practical implications of our response to COVID, which has been necessary to save lives, that Parliament has been physically unable to operate as planned. We remain in the Scottish Government absolutely committed to introducing legislation on fox control, and we intend to do this during the next Parliament if re-elected. This bill before us today is not the place to attempt to introduce new controls on hunting with dogs. So while I acknowledge the intent behind Mr Finney's amendment, it is neither needed here nor helpful in that it could affect a wide range of legitimate work carried out by dogs. I am sure that is not the intention, and I would hope that Mr Finney might withdraw his amendment accordingly. However, should he not withdraw it, I would hope that the committee would not support it. Thank you, Convener.
Thank you, Minister. I now call Emma Harper to speak to this amendment. Emma Harper.
Thank you, Convener. Good morning to everybody. Mr Finney has set out his reasoning for lodging this amendment, and in essence, the 1953 Act makes the owner of a dog criminally liable if the dog is at large in a field of sheep, but it includes an exemption for specific categories of dog, including a dog lawfully used to hunt. This amendment, in the name of John Finney, does two things. It removes hunting dogs from the exemption, and it removes the new provision added by the bill that all categories of dogs listed in the 1953 Act, including those added by the bill, are only exempted when they are performing the role in question. I don't support either of the effects of this amendment. On the first point, I agree with Christine Graham that I don't consider this bill, my member's bill, to be the right vehicle to pursue hunting-specific concerns. And as the Minister has just spoken, it is likely that the issue of hunting will be considered in the next session of Parliament, and such issues should be considered then in their full context and with a full debate with the stakeholders and the public. I also do not support removing the qualification added by the bill that the exempted dogs are only exempt when performing the role in question. This qualification was not criticised during stage 1 process, and there have been no suggestions that it should be removed. It adds a helpful qualification to the 1953 Act and ensures that, for example, a guide dog is exempted only when performing the guide dog role, but otherwise should be treated like any other dog, for example, when being exercised by a sighted person. This provides added protection for livestock owners, and I do not support weakening the bill by removing this provision. And just on Monday, I spoke with one of the inspectors for the Scottish Partnership Against Rural Crime, and they have not had any evidence of livestock being attacked or worried by dogs used in control of foxes. So for these reasons, I urge the committee to reject this amendment.
Thank you, Emma. And I'll now go back to John Finney to wind up and press or withdraw your amendment. John.
Sorry, thank you very much indeed, Convener, and can I thank members who have taken part in the debate. We're debating the protection of livestock. I was talking about the protection of livestock. Now, that members have chosen to take a different approach to the discussion is for them. The debate has been peppered by euphemisms. We start with Mike Rumbles with the term pest control. I take great exception to Mr. Halker-Johnson's pejorative comments that I am not, it's an ideological, and I'm not interested in the welfare of livestock. That's a disgraceful and shameful thing to say, and I hope he'll reflect on that and offer an apology. Christine Graham, well, I have a very high regard for our Deputy Presiding Officer, and particularly when it comes to parliamentary procedures. But of course, it would have been helpful if Christine had been aware of all the evidence that's been offered in relation to this. So I don't accept a reprimand. I most certainly don't accept any suggestion regarding competence, because quite clearly, if it's incompetent, Convener, you would have ruled it as such. So this is a perfectly competent amendment, and it comes from a very sound basis. And as is frequently the case, I'm particularly grateful to my colleague Colin Smith, who gave a very detailed resume of the basis on which we have had evidence on this, and Colin went on in great detail about that. As regards, excuse me, as regards your own contribution, Convener, and talking of the margins and juniper bushes, well, that's the sort of territory I'm very familiar with, and fairness to you accurately outlined the law as it's supposed to operate. But as we go on to hear from the Minister, that's not how it is operating in practice. That's not how it's operating in practice. And again, you know, phrases like trying to advance an agenda, I never once mentioned foxes in relation to this. And on the question of safeguarding, well, the Minister mentioned safeguarding. Yeah. The piece of legislation that we're talking about at the moment is about safeguarding livestock. And I hear the member in charge of the bill suggesting that the proposal, which I'm not putting forward, should be the subject of full debate. For the avoidance of any doubt, of course, I would like to see a ban on fox hunting, and though I'll not be around next term, I wish the incoming government, if indeed it is the Minister's government, the very best in doing that, because what we do know is that livestock have been harmed. Livestock have been harmed. But of course, the inducement of compensation paid to landowners that hunts over has been seen as some way of offsetting the concerns. But my concern here is it's simply the well-being of livestock. And I go right back to what I said at the beginning. It's not a good idea to have any dog loose among livestock. It's even less good an idea to have a number of dogs loose. That can have an impact on the well-being of livestock. That's my simple concern here, and I move the amendment in my name. Thank you.
Thank you, Mr. Finney. And just before we go to vote on the amendment, I would just point out that Christine Graham is here as a member of the committee, and while she has another role within the Parliament, that has nothing to do with her role in the committee. So just an observation. And so, having moved the amendment, the question is that Amendment 1 be agreed. Are we all agreed? No, we're not agreed. Therefore, there will be a division. Could all those please in favour of the amendment type Y in the chat function now, please? Thank you. All those against, please type N in the chat room now, please. And anyone who wishes to abstain, please type A in the chat room now, please. Thank you. Sorry, it's the first vote and just need to make sure we get this right. So, okay. There is She has voted now. It's just come through. Sorry, there was one member who appeared not to have voted. We now have all the votes. So those in favour of the amendment were John Finney and Colin Smith. Those against the amendment were Christine Graham, Richard Lyle, Angus MacDonald, Stuart Stevenson, Maureen Watt, Peter Chapman, Jamie Halcrow-Johnson, Edward Mountain and Mike Rumbles. There therefore were 2 votes for the amendment and 9 votes against. Therefore, the amendment was not agreed. I'd now like to call Amendment 2 in the name of the Minister, grouped with Amendments 3, 4 and 5. Minister, can I ask you to move Amendment 2 and speak to the other members in, the other amendments in the group? Minister.
Thank you, Convener. It is important that the range of penalties for offences under this bill are sufficient to be proportionate, but also appropriate for the seriousness of the offence committed. Throughout the consultation for this bill and during stage 1, we heard of quite horrific instances of the impact on farmed animals and farmers, crofters and their families when animals had been killed or horribly injured by dogs out of control on their land. We have considered the proposed penalties carefully and considered the recommendations of the committee's stage 1 report. And we have also considered the Animals and Wildlife Penalties, Powers and Protection Scotland Act 2020. And it has now commenced, and the maximum penalties available for many wildlife crime offences, as well as offences specified in regulations made under Part 2 of the Animal Health and Welfare Scotland Act 2006, other than regulations for fixed penalty notices, are now 12 months imprisonment or a fine of up to £40,000 or both. Accordingly, I therefore consider it important to ensure consistency of approach to penalties in this bill with the increased maximum penalties the 2020 Act made available for animal welfare offences and a wide range of wildlife crime offences. My amendment therefore proposes to increase the maximum penalty in this bill from 6 months imprisonment and or a level 5 fine, currently £5,000, to 12 months and or a £40,000 fine. This would also still rightly allow for courts to impose appropriate penalties, depending on the particular facts and circumstances of the case. Amendments 2 and 3 are the substantive ones here. Amendments 4 and 5 are consequential and technical. I hope the committee members will agree with this approach and support amendments 2, 3, 4 and 5. And I move this amendment in my name. Thank you.
Thank you very much. I have got Mike Rumbles who wants to speak on this amendment.
Thank you, Convener. I have no issue about raising the fine. If there's damage done to that extent to stock, then absolutely correct. I really would like to ask the Minister a question, if he's given an opportunity to respond to me on this. It's really on Amendment 2. Imprisoning somebody for 6 months and imprisoning somebody for 12 months, does he think there's any difference in deterrence or in punishment? I mean, I would imagine sending somebody to prison would be enough deterrent or enough punishment. Why, other than just be tidying up legislation, which is what I was listening very carefully to the Minister, because other legislation has this in, oh, well, let's make this one the same. I'm actually concerned that we just increase imprisonment levels because it sounds tough. So what I'd like to know is, what's his evidence for that, other than just tidying up legislation? Is there any evidence to suggest that moving from 6 months imprisonment to 12 months imprisonment is reasonable?
A question then, and I'm not sure that this is the time to take evidence during the session, but Minister, if you'd like to come back and respond to that, I'm delighted to let you in. If not, I will move on to the member. Minister,
perhaps,
do you want to come back?
I could address that in my summing up.
Okay, thank you very much. No one else has indicated they wish to want to speak, so I'm going to call them Emma Harper. Emma.
Thank you, Convener. As the Minister has explained, the bill increases the maximum penalties available. This was a key part of my policy. I wanted to increase the maximum available penalties significantly to act as a greater deterrent while setting them at an appropriate level to acknowledge that in most instances there is not intent by the owner to cause harm. During stage one, the former Minister noted that there may be a case for increasing the penalties even further to match those available under the Animal Health and Welfare Scotland Act 2006, as amended by the Animal and Wildlife Penalties, Powers and Protections Scotland Act 2020. This 2020 Act had not been passed when my bill was consulted on or drafted. So the committee stage one report supported the government's view and recommended amending the bill accordingly. I'm content to support amendments 2 and 3 in the name of the Minister to further increase the maximum available penalties in the bill to a maximum prison sentence of 12 months and a maximum fine of £40,000. Amendments 4 and 5, also lodged by the Minister, have the effect that the increased maximum penalties in the bill and the order-making powers under Section 2 only apply to offences committed after those provisions have come into force. And I agree with the policy intention that the new penalties and order should only apply to offences committed and after the Act comes into force, and I'm therefore content to support these amendments. Thank you.
Thank you very much, Emma. Minister, I'll allow you to wind up. Sorry, that's very condescending. Minister, would you like to wind up? Sorry, I'll rephrase that.
Thank you, Convener. Yes, I would be grateful to and thank Mr. Rumbles and Ms. Harper for their comments. The action that these amendments seek to undertake in terms of the amendments to the bill are in line with the recommendations of the committee and the discussions that we had collectively at stage one in the chamber. And the determination of the amendments, as I put forward in my opening remarks, is to, quite rightly in the government's view, ensure consistency of approach to penalties with the increased maximum penalties now available for a wide range of animal welfare and wildlife crime offences. In terms of the specific questions from Mr. Rumbles around the effect of sentencing on the propensity to offend, I think that's a wider question, perhaps for others in the Justice Committee or elsewhere to consider. The point is that our approach to sentencing is based on the seriousness of the crime in question, and it was deemed by the committee and by this government in bringing the amendments that in order to emphasise the seriousness of the crime that we are discussing today, it was right and appropriate to bring in amendments in order to make sure that there was a consistency of approach to penalties with the increased maximum penalties now available for a wide range of animal welfare and wildlife crime offences. Thank you, Convener.
Thank you very much, Minister. We now come to the question, is that Amendment 2 be agreed? Are we all agreed? If you're not, type an N in the chat box, just an N if you don't agree. Okay, so we are not agreed. So there will be a division. Can I ask all those in favour of the amendment to type Y in the chat room now, please? All those against, please tap an N in the chat room now. And anyone who wishes to abstain, please type an A in the chat room now. Thank you. The results were as follows. Those in favour amendment is Christine Graham, Richard Lyle, Angus MacDonald, Stuart Stevenson, Maureen Watt, Peter Chapman, Jamie Halcrow-Johnson, Edward Manson, John Finney and Colin Smith. Those against the amendment were Mike Rumbles. Therefore, there were no abstentions. There were therefore 10 votes for the amendment and 1 vote against, and therefore the amendment was agreed. The question, therefore, is that amendments. Oh, sorry. Yeah, my mistake. I'd like to call Amendment 3 in the name of the Minister, already debated with Amendment 2. Minister, could I ask you to move it formally, please?
Formally moved, Convener.
Thank you very much. The question, therefore, is Amendment 3 be agreed? Are we all agreed? Just type an N in the chat room if you don't. We are agreed. Therefore, I'd like to call Amendment 4 in the name of the Minister, already debated with Amendment 2. Minister, can I ask you to formally move it, please? Sorry, I didn't hear, Minister. Did you say you'd moved it?
Formally moved, Convener, yes.
Thank you very much, Minister. The question, therefore, is Amendment 4 be agreed? Are we all agreed? Okay, we are agreed. The question now is that Section 1 be agreed to. Are we all agreed? We are agreed. I'd therefore like to call Amendment 5 in the name of the Minister, already debated with Amendment 2. Minister, can I ask you to move it formally, please? Thank you. The question is that Amendment 5 be agreed. Are we all agreed? We are agreed. The question, therefore, is Section 2 be agreed. Are we all agreed? We are agreed. Now move on to the next lot, which is the removal of powers to appoint inspecting bodies and inspectors. I'd like to call Amendment 6 in the name of Emma Harper, grouped with the amendments shown in the groupings. I would like to draw members' attention to the preemption information in the groupings. If amendment in the group 15 in the group, removal of ability to search, etc., without warrants is agreed, I therefore cannot call Amendment 14 in this group. Can I ask Emma Harper, please, to move Amendment 6 and speak to all amendments in the group? Emma.
Thank you, Convener. Yes, I move Amendment 6. And I will speak to the other amendments. At present, the bill allows the Scottish Ministers by regulation to appoint inspecting bodies, which in turn can appoint inspectors. The policy intention was to allow for more formal support to be provided to the police if that was thought necessary. However, I note that the evidence at stage 1, including from the police and the SSPCA, that the provisions may not be required and that no organisation seemed willing to take on the role of inspecting bodies. I also acknowledge the committee's stage 1 report and its recommendation to remove these provisions. To achieve this, I have lodged Amendment 22 to remove Section 5 entirely. The other amendments in this group remove all reference to inspectors and also cross-references to Section 5 or to the provisions it would insert into the 1953 Act. I move Amendment 6 again.
Thank you very much, Emma. And I think Colin Smith, you want to contribute. Colin.
Thank you very much, Convener. The amendments in this group, which I'm a supporter of, I think reflects the calls made in the committee's stage 1 report, where we noted, and I quote, fundamental concerns about the principle of inspection bodies taking the lead any circumstances in which a criminal offence of livestock willing has taken place. And we made a very clear recommendation that the member in charge should remove the inspecting bodies provisions from the bill during the amended stage of the bill, should it proceed. I think these recommendations were made following concerns from a number of stakeholders on the role of this new body, and I think a lack of clarity about their intended role, indeed whether the enabling powers would be used at all. I think there was also widespread agreement among stakeholders and committee members that the police remain the most appropriate body to lead investigations on this issue. I think there's a need for more specialism when it comes to investigating animal welfare and wildlife crimes, and I think there remains a discussion to be had about the best way of achieving this, but I think the vague enabling powers proposed in the bill were not the best way to go about this. I asked the Bill's team to move them, for amendments to remove them to be drawn up, but I felt it fair to wait to see if the member in charge would take a similar approach and table amendments. So I'm pleased that Emma Harper has done so, and I certainly would support these amendments and strongly urge other members to also do so.
Thank you very much, Colin. And I think John Finney would also like to contribute. John.
Thank you, Convener. It's a brief comment, Convener. I like Colin, will lend support to these amendments. I think they're entirely appropriate. I just wouldn't want any inference to be from the comments of the member in charge that it was the absence of any bodies coming forward that had any influence in my decision to reject this. I think Parliament has to be extremely cautious giving policing powers to any bodies, and it's for that reason I was always opposed to these amendments. But I do welcome the member bringing these proposals in the bill, but I entirely welcome the member bringing forward these amendments to remove this provision. Thank you very much.
Thank you very much, John. And Minister, would you like to make some comments, please?
Yes, please. Thanks, Convener. The Scottish Government supports these amendments to drop the provisions regarding inspecting bodies, including the power of the Scottish ministers to appoint inspecting bodies and the powers of search, entry and seizure, so far as they relate to the powers of inspectors. I want to assure the committee I have given this matter careful consideration and have noted the concerns expressed by the committee in its Stage 1 report. I understand the intention of those who seek a role for other bodies other than the police to investigate potential crime offences under this bill, but on balance, there are important reasons why across the full panoply of criminal law in Scotland, it is the police which is the investigating body. I'm also not convinced that other inspecting bodies are generally able or willing to take a leading role in investigations of livestock worrying. And therefore, I agree with Emma Harper that responsibility for investigating the criminal offence of livestock worrying should remain with the police, with assistance from local authorities or Scottish SPCA as appropriate in the circumstances. And I would hope the committee would support the amendments from Emma Harper. Thank you.
Thank you, Minister. And Emma Harper, I'd like you to wind up and just confirm whether you want to press or withdraw the amendment. Emma.
Thank you, Convener. I do want to press the amendment, and just for clarification, my intention was always that the police would be the leader in any investigation. The intention of the original amendments in the bill was so that the police could obtain support if necessary from local authority or an inspecting body that would be appointed. But based on the evidence that we had at Stage 1, I was happy to bring forward these amendments to remove references to inspecting bodies.
Thank you very much, Emma. The question, therefore, is that Amendment 6 be agreed. Are we all agreed? It appears we are all agreed. I therefore want to call Amendments 7, 8 and 9, all in the name of Emma Harper and all previously debated. Emma, could I ask you to move Amendments 7 to 9 en bloc, please? Sorry, I couldn't hear you. I'm assuming. Sorry.
Sorry, moved en bloc.
Thank you very much. Does any member object to a single question being put on Amendments 7 to 9? No one does. The question that therefore is that Amendments 7 to 9 are agreed. Are we all agreed? We are agreed. The question therefore that we come to now is that Section 3 be agreed. Are we all agreed? We are agreed. I'd like to call Amendments 10, 11, 12 and 13, all in the name of Emma Harper and all previously debated. I would like to invite Emma Harper to move the Amendments 10 to 13 en bloc. Emma, could you move those amendments, please?
Yes, Convener, I will move those amendments en bloc.
Thank you very much. Does any member object to a single question being put to Amendments 10 to 13? No one does. Therefore, the question is that Amendments 10 to 13 are agreed. Are we all agreed? We are agreed. I'd now like to call the Amendment 15 in the name of Emma Harper in a group on its own. I'd like to draw members' attention to the preemption information shown in the groupings. If Amendment 15 is agreed, I cannot call Amendment 14 from the group, removal of power to appoint inspected bodies and inspectors. Emma Harper, can I ask you to please to move and speak to Amendment 15?
The bill gives the police specific new powers to enter and search premises. This currently includes in new section 2A6 a power to do so without a warrant in specific circumstances. However, evidence was given at stage 1 by the police that the power would be very unlikely to ever be used and is not one that the police are seeking. I also acknowledge the committee's concerns on this issue during stage 1 and the recommendation to remove the provision made in the committee's stage 1 report. I therefore move Amendment 15.
Thank you very much. Mike Rumbles, I think you want to speak on this, followed by Colin Smith. Mike.
Thank you, Convener. I'd like to thank Emma Harper for bringing forward this amendment. She's quite right, of course. This is one of the major issues that the committee was concerned with. I was particularly concerned with it. And I had some experience on a previous parliamentary committee looking at the UEFA bill. And in fact, the Minister, Ben McPherson, this was raised in a previous bill, and the Minister recognised that it wasn't appropriate. And I'm very pleased that he's done so again. The committee feels the same way, and so does Emma. It has, with this amendment, removed something which I thought was contrary to common law in Scotland. And it's very important that when the police, as they have to, and are required to search premises, they obtain the appropriate warrant from the appropriate authorities, then we don't allow simply the police to go on fishing expeditions. I did notice in the evidence from the police that they didn't want it, and they would hardly ever use it. But the problem was that if it was in the legislation, it could be used. And so I'm very pleased that Emma has recognised this and brought forward the amendment, and I fully support her in doing so. Thank you.
Thank you, Mike. Colin, I think you want to contribute, Colin.
Thank you very much, Convener. I think Amendment 15, lodged with Emma Harper, voted by myself and Mike Rumbles. It is an important one. In our stage 1 report, the committee stated that we had, and I quote, very real concerns about the powers proposed in this section of the bill and questions whether they are legally competent. And we concluded that we were, again quoting, therefore not persuaded that the powers of entry, search and seizure without a warrant are required. So I'm pleased that the member in charge has listened to those points and concerns raised by a number of stakeholders during our scrutiny of the bill and brought forward this amendment. I mean, granting police a new ability to enter a premises without a warrant is not a decision that should be taken lightly, and it is not a power that should be granted without a very clear need to do so. The evidence we received called into question what purpose these powers would serve in practice, and we also didn't find any real demand for these powers from law enforcement. So in light of this, I asked for an amendment this to be drawn up with the Bills team, but again held back to see whether Emma Harper would submit an amendment to this effect. I'm pleased she did, and I'm therefore very happy to support this amendment.
Thank you, Colin. Minister, would you like to make some comments? Minister.
Just briefly, thank you, Convener. After further discussion with the Crown and Prosecution Service, the proposed power of entry, search and seizure without a warrant relating to non-domestic premises does seem unlikely to be required or used in practice if the police remain the investigating authority. Therefore, as members, similar to what members have already said, the Scottish Government supports this amendment to drop those provisions in view of the concerns raised by the committee. Thank you, Convener.
Thank you very much, Minister. And Emma Harper, can I ask you to wind up and press or withdraw your amendment?
Thank you, Convener. Yep, I acknowledge the concerns from the committee, and especially when we took evidence, and I obviously am welcoming the input from Mike Rumbles and Colin Smith the power to enter without a warrant was only for non-domestic premises, but I take on board all the evidence that was presented, and on further ongoing engagement with the Scottish Partnership Against Rural Crime team, I was assured that this was not, that entering premises without a warrant was not required. So I am happy to move my amendment.
Thank you. The question we come to, therefore, is that Amendment 15 be agreed. Are we all agreed? We are agreed. Therefore, I'm now going to call Amendments 16, 17, 18, 19, 20 and 21, all in the name of Emma Harper and all previously debated. Now I invite Emma Harper, please, to move Amendments 16 to 21 en bloc. Emma.
Moved en bloc.
Thank you. Does any member object to a single question being put on Amendments 16 to 21? No. Therefore, the question is that Amendments 16 to 21 are agreed. Are we all agreed? We are agreed. We now call Amendment 28 in the name of Peter Chapman, grouped with Amendment 29. Peter Chapman to move Amendment 28 and speak to both amendments in this group. Peter.
Thank you, Convener, and I move Amendment 28 in my name, and I'll be very brief. Amendment 28 is very clear and simple in what it says, and to me it's all about ensuring fairness. You know, in any outbreak, the first person that the farmer will call is his vet, if there are animals, you know, injured and dying. After that, he may or may not phone the police, but he'll certainly phone his vet. So the farmer's vet will absolutely be on site when the police arrive, and if there is a dog held and needs to be examined, it will be absolutely done by the farmer's vet, because he will be on site and he will be available to do that work. All I want to ensure is that the farmer doesn't end up picking up the bill for doing that work of examining the dog. And as far as I'm aware, nowhere in the bill does it specifically say that the police will pick up the tab or will pay for that examination of any dog that might be held. And so my amendment is basically to make that absolutely clear, that if the farmer's vet does that work and does examine the dog, then that part of the vet's bill is picked up by the police and not by the farmer. And I'll leave it there. And as far as Amendment 29 is concerned, it's about making arrangements for any more specialist investigations that may or may not be needed, that perhaps a local vet can't provide. And I'm thinking here about taking DNA samples, for instance. And I would envisage that perhaps the SRUC vet labs may be one example of where that kind of specialist work could be undertaken. And basically the amendment in my name just tasks the government with having the ability for that kind of specialist work to be done if necessary. And I'll leave it there, Convener.
Thank you very much, Peter. Now a couple of members have indicated they wish to speak, so I'll go to John Finney, followed by Jamie Halcrow-Johnson. John.
Thank you, Convener, and I would like to speak in support of Mr Chapman's amendment, which I think is entirely reasonable. The one caveat I would like to put in place is something that we discussed in the course of our deliberations, Convener, and that is the potential for securing the best possible evidence and avoiding cross-contamination of evidence. That doesn't take anything away from Mr Chapman's amendment. I think it's quite proper, but it perhaps needs to be underwritten by some protocol, which I'm sure vets would have regard to anyway, but the forensic aspect of acquiring evidence for a criminal case perhaps might be not the norm for the farmer's vet. So I think, whilst happy to support this, it will need to be underpinned by some protocols, perhaps between the Crown and the police about the acquisition of evidence and avoiding cross-contamination. Thank you.
Thank you very much, Mr Finney. Jamie Halcrow-Johnson. Jamie.
Thank you very much, Convener. Just very briefly, just to say I support Mr. Chapman's amendments, and particularly Amendment 28, which I think is a useful clarification and recognises some of the practical implications and practical situations that we may find ourselves with the legislation. So just to, I say, give my support to both.
Thank you very much, Jamie. No other members indicated they wish to speak. Therefore, I'd like to call the Minister.
Thank you, Convener. I thank Peter Chapman for explaining the purpose of his amendments 28 and 29. However, I cannot agree that these amendments are either necessary or desirable, and I urge him not to press them, and this is why. Firstly, Police Scotland will currently pay for the cost of a veterinary examination of dogs suspected of livestock worrying in those cases where they consider this is appropriate to gather evidence for a potential prosecution. We have supported amendments already in the proceedings this morning that will ensure that Police Scotland remain the only investigating body involved. So there is no need to introduce a new requirement in law for Police Scotland to pay for the costs of gathering evidence. The situation that Mr. Chapman described, I think, is worth some consideration, though, and I would be very happy to work with Peter Chapman ahead of stage 3 to give him comfort that the situation he describes could be covered in guidance or otherwise, and we'd welcome that discussion were he to withdraw Amendment 28, which I do not support and ask that it be withdrawn. However, should Mr. Chapman press his amendment, I hope members of the committee would agree not be making law for the sake of it, especially when there is no deficiency requiring to be remedied here. So I would encourage members to resist Amendment 28. Amendment 29 would place an unnecessary and onerous burden on the Scottish Government to provide additional veterinary services to examine any dogs suspected of worrying livestock after they have been seized by Police Scotland. As we stated at stage 1, there are various possible scenarios where it might be appropriate for forensic evidence to be collected from a live suspect dog to link the dog to a particular attack. Such cases are rare, and the need to collect and analyse evidence would be agreed in advance by Police Scotland with the Crown and Procurator Fiscal Service, depending on its potential relevance to any possible prosecution case. If it is appropriate to gather evidence from a live dog, there are different ways of arranging this depending on the availability of suitably trained persons to handle the dog. This could involve Police Scotland officers with the assistance of other enforcement authorities, the Scottish SPCA, or local veterinary practices as appropriate for the particular circumstances at the time. To require a blanket approach in law that whereby the government would have to provide veterinary surgeons able to examine suspect dogs anywhere in Scotland and in all circumstances and cases would be disproportionate, not least in terms of the cost, but also because it would cut across current practice in that it is quite straightforward currently for dogs to be presented to local veterinary practitioners for examination at the request of Police Scotland when this is necessary. So the situation overall is what I've just described does not require any new arrangement for veterinary services, specialist facilities, or any new legislation. I therefore do not support Amendment 29 and also request that it be withdrawn. However, should Mr. Chapman press it, I encourage members to resist it for the reasons I've said. Thank you, Convener.
Thank you very much, Minister. And I'd now like to call Emma Harper. Emma.
Thank you, Convener. In relation to Amendment 28, this issue was raised by Mr. Chapman during the Stage 1 evidence sessions. I referred to an experience that I had of speaking to one local vet who said that if he was taking evidence for a livestock worrying case, he would normally he would normally do what would be similar to what he does in his usual work. For example, he would take blood, take swabs, give an emetic to the dog. So this would be a usual practice for a vet anyway. My understanding is that since the police, as the investigating body, would be arranging for the examination, they would be responsible for paying for the examination in the first instance and would only be able to reclaim that cost from someone else, such as the dog's owner, if there was statutory authority to do so. On that basis, I do not consider the amendment to be necessary, and I do not support it. The amendment would also introduce a new reference to an inspecting body into the bill, even though the committee has just agreed to remove the provision for allowing inspecting bodies to be appointed. And on Amendment 29 and the need for support for examinations, it is, again, normal practice for vets to take blood or swabs, and qualified vets are already competent to do so. It's therefore unclear what this amendment would add. The amendment is also unclear about what the arrangements that it refers to would consist of or what they would have to include. I agree with the Minister's view that no statutory power for SRUC or local vets is required in the legislation, as they can already be involved in collecting evidence from animals presented to them by the police. On that basis, I do not support this amendment.
Thank you very much, Emma. Peter Chapman, can I ask you to wind up and press or withdraw Amendment 28, please? Peter.
Thanks, Convener, and I welcome the comments from both Emma Harper and the Minister and John Finney's support. I think this is a very simple and worthwhile amendment, but I do accept what the Minister has just said, and I also accept the fact that we have just removed the other bodies from the bill, that this becomes less necessary now that we've agreed that the police are the body that will prosecute the case. I do have more confidence, given that we have already taken the other bodies out of the equation, and I do welcome the Minister's opportunity to discuss this further with him. And I also, have to accept that what he says is that the police actually do accept that they will have to pick up the tab for this work. So, given all that, and given that the Minister will work with me to ensure that this is absolutely clear, and maybe something in the guidance is what we need rather than in the bill. And if we can get something in the guidance, which the Minister did say that he might consider, I would then be prepared to withdraw Amendment 28 in my name, Convener.
That sounded like a conditional withdrawal. Are you withdrawing it, or are you pressing it?
No, I am withdrawing it. Given that the Minister has said he's prepared to work with me, then I will withdraw it.
Okay, thank you. So I have to ask, if you're withdrawing Amendment 28, whether any member wishes to objects to your withdrawing that amendment. You do just type a O in the chat room, but no one is doing that. Therefore, the question I have to ask is that Section 4 be agreed. Are we all agreed? On the basis, sorry, before I say that, on the basis that Amendment 28B is withdrawn, the question is that Section 4 be agreed. Are we all agreed? We are agreed. Therefore, I call Amendment 22 in the name of Emma Harper, already debated with Amendment 6. Emma Harper, can I ask you to move that amendment, please? Or not move it?
Moved.
Okay, thank you. The question, therefore, is that Amendment 22 be agreed. Are we all agreed?
Make sure I move everything.
Sorry, was that at me, Emma?
No, I'm just thinking out loud. Apologies.
Okay. No, sorry, I was concerned it might be an instruction I was missing. Therefore, that is agreed. Now, Amendment 29 was not moved. Okay, well, I have to technically ask you, Mr. Chapman, whether you want to move Amendment 29 or not move it.
Not moved.
Okay. So we move on to the next set of amendments, which is Amendment 30 in the name of Jamie Halcrow-Johnson in a group on its own. Jamie Halcrow-Johnson, can I ask you to move and speak to Amendment 30? Jamie.
Thank you very much, Convener, and I'm happy to move Amendment 30 in my name. This amendment seeks to clarify for the purpose of the bill that agricultural land will include woodland use for grazing. It would amend the interpretation clause in section 3, brackets 1 of the 1953 Act. The definition of agricultural land found in the 1953 Act is already broad. However, increasingly woodland is being utilised for low density grazing, something that would not have been foreseen when the Act was drafted. Just to kind of clarify, Forest Research, which operates as part of the Forestry Commission, has noted that cattle are thought to provide biodiversity benefits in woodlands when grazed at low density, since they eat vegetation of a low digestibility and break up vegetation mats with their hooves. And they highlighted that because of these perceived benefits, there is increasing interest in the use of cattle as a tool for nature conservation management in woodlands. Convener, done well, woodland grazing is something that a range of environmental bodies, including Scotland's forests, are working to encourage. And the amendment was simply put beyond doubt that agricultural land would include the area of increasing interest, and provide woodland grazers with the same protections available to those as other types of land. So I hope members will support my amendment, and I support all the other amendments in this group.
Thank you. Maureen Watt, I think you want to come in. Deputy Convener.
Yes, thank you, Convener. Can I welcome this very helpful amendment from Jamie Halcrow-Johnson. As he said in his remarks, grazing in woodland is becoming increasingly common because we know that bracken in many cases is a nuisance, and not only cattle who might be now grazing in woodlands, but with an increase in other types of livestock in Scotland. Pigs are good at turning up land in woodland too, but we get wild boar and other livestock breeds coming in, and I think, as others have said, to increase biodiversity and also have better land use, it is important that we put this amendment in here, which is to be welcomed, and I hope everyone will support it. Thank you.
Thank you very much. Maureen, Minister, would you like to say anything?
Thank you, Convener. Welcome the discussion on this amendment. This amendment is potentially unnecessary, as the definition of agricultural land under the 1953 Act focuses on the use of the land in question. If woodland is used for the purpose of grazing animals, then it is likely that it would be considered grazing land and therefore agricultural land for the purposes of the 1953 Act. However, considering the increase in woodland planting and woodland grazing systems that are becoming more common in Scotland, which is a good thing, I can see the amendment might in the future be helpful to confirm that woodland used for grazing is considered as agricultural land for the purposes of the Dogs Protection of Livestock Act, and therefore the Scottish Government has no objection to this amendment, the clarity that it would bring. Thank you.
Thank you, Minister. Can I ask Emma Harper, do you have any comments to make?
Yep, thank you, Convener. The definition of agricultural land in the 1953 Act includes grazing land, but grazing land is not expanded on further. Amendment 30 would ensure that woodland that is also used for grazing counts as agricultural land. I welcome Jamie Halcrow-Johnson's comments on the expanding use of land and Maureen Watt's comments about bracken, wild boar and pigs, obviously. I have no strong views on whether this change is needed, but if the Minister and the committee thinks it would help, then I won't oppose the amendment at this stage.
Thank you very much, Emma. Jamie Halcrow-Johnson, can I ask you to wind up and press or withdraw your amendment, please?
Thanks very much, Convener. And I'm grateful to Maureen Watt and to Emma Harper and to the Minister for those comments, and the Minister for his however at the end of his comments. And I think the recognition that this does provide potential future proofing for the bill. So I will press the amendment in my name.
Thank you very much, Jamie. The question, therefore, that we come to is that Amendment 30 be agreed. Are we all agreed? We are agreed. Therefore, going to call Amendment 23 in the name of Emma Harper, already debated with Amendment 6. Emma Harper, to move or not move, please.
Moved.
Okay. The question, therefore, is that Amendment 23 be agreed. Are we all agreed? We are agreed. Therefore, I'd like to call Amendment 24 in the name of Emma Harper, already debated with Amendment 6. Emma Harper, to move or not move.
Moved.
Thank you. The question, therefore, Amendment 24 be agreed. Are we all agreed? We are agreed. I therefore call Amendment 25 in the name of Emma Harper in a group on its own. Emma Harper, can I ask you to move and speak to Amendment 25? Emma.
Thank you, Convener. With the removal of inspection bodies provisions in the bill now contains only one delegated power, which is a power for Scottish ministers to make regulations to amend the definitions in Section 3(1) of the 1953 Act. The bill states that such regulations are subject to the negative procedure. However, the Delegated Powers and Law Reform Committee recommended in its report at stage 1 that the affirmative procedure be considered, given that the change of a definition could have an impact on whether an offence has been committed. This recommendation was supported by the REC Committee in its stage 1 report. I therefore move Amendment 25.
Thank you very much. No other members indicated they wish to speak in this amendment, so I'm going straight to the Minister. Minister.
Thank you, Convener. I thank Emma Harper for bringing forward this amendment and explaining its purpose. The bill allows for future changes to the definitions of livestock and indeed all other definitions contained in the 1953 Act. This amendment will ensure relevant and proportionate parliamentary scrutiny for any changes of definitions by requiring future regulations to follow the affirmative process. That is in line with the recommendations of this and the DPLR committee, and I and the Scottish Government are happy to accommodate that, so I hope members will support Amendment 20.
Thank you, Minister. Emma Harper, you can just press this or wind up and press it if you like.
Happy to press this and no further comments.
Thank you very much, Emma. The question, therefore, is Amendment 25 be agreed. Are we all agreed? We are agreed. The question, therefore, we come to is that Section 6 be agreed. Are we all agreed? We are agreed. I'm now going to call Amendment 26 in the name of Emma Harper in a group on its own. Emma Harper, can I ask you please to move and speak to Amendment 26? Emma.
Thank you again, Convener. This is a minor technical drafting amendment to Section 7. Currently, the section refers only to Section 1, but does not specify the Act, that being clear only from the section title. I understand it would be normal drafting practice to specify the Act in the body of the section as well as in the section title. I therefore move Amendment 26 in my name.
Thank you very much, Emma. No other members indicated they want to speak in this amendment, so I'm going straight to the Minister. Minister.
Thank you, Convener. Just very briefly, I'm happy to support this amendment. Thank you.
Perfect. Thank you. Emma Harper, can I ask you to wind up if you need to and press or withdraw the amendment?
No need to wind anybody up, Convener. I'm happy to move the amendment.
I'm delighted you're not going to wind me up, Emma, and therefore we will move to the question, which is Amendment 26 be agreed. Are we all agreed? We are agreed. The question, therefore, is that Section 7 be agreed. Are we all agreed? We are agreed. The question is that Section 8 be agreed. Are we all agreed? We are agreed. I therefore like to now call Amendment 27 in the name of Emma Harper, already debated with Amendment 6. Emma Harper, to move or not move?
Move, convener.
Thank you very much. The question is that Amendment 27 be agreed. Are we all agreed? We are agreed. The question, therefore, is that Section 9 be agreed. Are we all agreed? We are agreed. The question, therefore, is that Section 10 be agreed. Are we all agreed? We are agreed. The question is that the long title be agreed. Are we all agreed? We are agreed. That ends Stage 2 consideration of the bill. The bill will be reprinted as amended at Stage 2 and will be published, I believe, tomorrow morning. The Parliament has not yet determined when Stage 3 will be held. Members will be informed of that in due course, along with the deadline for lodging any Stage 3 amendments. In the meantime, Stage 3 amendments can be lodged with the clerks in the legislation team. That concludes that item, and I believe at this stage I formally thank Emma for her attendance and say don't disappear, and also thank the Minister for his attendance, and I also thank Christine Graham for her attendance, and I think she now disappears, allowing Emma back onto the committee. And we will move on to agenda item 2, which is subordinate legislation. And just for committee members' knowledge, what we'll do is we'll work through these agenda items, and then we will take a brief pause before we go on to discuss the climate change plan letter in a private meeting. So we'll push on now with agenda item 2, which is the consideration of subordinate legislation. And this is 3 negative instruments as detailed on the agenda. The Delegated Power and Law Reform Committee considered 3 negative instruments and no issues were raised. No motions to annul have been received in relation to these instruments. Does any member have any comments they wish to make? I'm not seeing any. Therefore, I propose that the committee does not wish to make any recommendations in relation to these negative instruments. Does any member disagree with that? No one does, so that's agreed. We'll move on, therefore, to item 3, which is European Union Withdrawal Act 2018. We have received a consent notification in relation to 1 UK statutory instrument, as detailed at item 3 on the agenda. This instrument is being laid in the UK Parliament in relation to the European Union Withdrawal Act 2018. This instrument has been classified as Type 1. Does any member have any comments? No one appears to have any comments. So does the committee agree to write to the Scottish Government to confirm it is content for consent for the UK SI referred to in the notification be given? That is agreed. Therefore, we are now going to move into private session to discuss our climate change plan letter. I would ask members please to note that we will, I would like you back on the other means at 10:55. I think that gives you a wee break. So thank you very much, and we now move into private session.